Be seated. Mr. Brooks, before I have you question this witness any further, it sounds like to me that you are attempting to offer through this witness the statements made by Mr. Lascano. If that is what you are trying to do, you may not do that. You will have to call Mr. Lascano as a witness if you so choose, if he's on your witness list. But that your questions are seeking to elicit hearsay from this witness. That's why I had the jury removed so I could explain my ruling and why I'm going to direct you not to ask this witness questions about what Mr. Lascano may or may not have said.
I'm reading directly from his report.
That would be double hearsay then, because it's not you need Mr. Lascano here to say what he told this officer. If you are attempting to offer it for the truth of the matter asserted, which is what I believe you are doing, you're attempting to establish the veracity of something Mr. Lascano either said or didn't say through another witness. That is hearsay.
So it's not hearsay for the prosecutor to bring up.
I'm not going to talk about other rulings. There's been an objection by the state, and I'm sustaining the objection, and I'm directing you not to ask this witness questions that would call for this witness to say what Mr. Lascano said. That is hearsay. That is textbook hearsay, Mr. Brooks.
And then I don't think it's fair for me to object to hearsay from the prosecution along the lines of the same type of thing.
I'm not going to have a debate on what may have come in previously. I know you've made a number of hearsay objections, many of which the answers that were being provided were not hearsay. But I would direct your attention to 908.01 of the Wisconsin statutes. You have that book in front of you that I provided to you a number of days ago at the beginning of this trial or near the beginning of this trial. There's the definitional section of the statutes, which defines hearsay. It also, and then if you go on to 908.02, that's obviously one you may want to look at as well. And then 908.03 has the exception. So unless you can give me an exception, sir, as to why this witness should be allowed to answer those questions, I'm going to, again, direct you not to ask these questions. I'm reading
directly from his report, the report that he wrote. Nothing is coming from. I'm reading directly from his report. That's what I have in front of me.
Doesn't change the fact that it's hearsay.
You said what?
That doesn't change the fact that it's hearsay.
So his report is hearsay?
Another level of hearsay. It's an out-of-court statement.
So
not this witness made, but what another witness made. So you have to...
So I can't read from his report that he wrote?
You can't ask this witness questions that call for a hearsay answer unless there's no objection from the state. Or you can convince me there's an exception to the hearsay rule that applies. Do you have an exception you'd like to offer to the court? So
I might as well not read the report that he wrote then if I can't question him about the report that he wrote.
That's your misunderstanding, sir, what is hearsay. And all I can tell you is I'm sustaining the objection. I'm going to bring the jury back out, and we'll go from there. All right, Madam Clerk, bring the jury out, please.
Clear bias.
Mr. Brooks, I understand you may disagree with
or agree to being called that name. For the record, again, I'm here as a third-party intervener on behalf of my client. I don't know why that's not understood by now. So I guess I can't bring up the plaintiff either, huh? Tacit agreement.
All right.
Thank you, everyone. Please be seated. Continue with your questions, sir.
I gotta tread lightly.
The jury will disregard that last comment.